Okay, we have a little Asia playing the Buggles here as a background. Video killed the radio star. And unfortunately, you have me re-recording the last segment that I had filmed in my jacket and tie, but ran too long to load up on YouTube. So at this point, with that little bit of a break, we'll come back and we'll talk a little bit to close down the Clarett conversation. And I'll make sure I stop this time at the 10-minute mark because YouTube doesn't allow me to load up more than 10 minutes. All right, let's get you the casual Bob Boland. I'm in shorts and a t-shirt and my running shoes, and I'm doing laundry downstairs in the basement. So you're getting me, kind of the non-professor but regular guy. And let me talk for a moment about the ultimate implication of the Clarett decision. We clearly see this tale of two cases, and we see this friction between the two decisions. Judge Scheinland's decision in the first case and Judge Sotomayor's and the Court of Appeals in the second case. Obviously the Court of Appeals wins because they're higher. They also decide this is a matter of law and remand, so Clarett loses, and he loses his career in a year in the NFL, and ultimately goes to prison, and his life spirals downward and out of control. But the interesting part about all this, and one of the more interesting parts, is it really does show the great dynamic between labor law and antitrust law, and how in a situation, at least this situation, where the union and the owners agree, and they have reached it through arm's length bargaining, or would have, how that's going to be given extraordinary deference by the courts. And not even antitrust claims, not even claims of monopoly and arbitrary practices are going to beat that. So as a consequence, and as we look at this, we're seeing a very, very dynamic area of law that's going to give incredible power to any issue where the players' union and its owners agree in pro sports. Remember, we've talked that unions are symbiotic with sports, kind of like that Finding Nemo anemone and clownfish scenario, or the shark and the remora. They are symbiotic because what do the pro sports leagues get from the union? They get the bulk of their antitrust protection. So the Clarett decision is very, very important. I often joke that I could teach antitrust by looking only at Clarett 1 and only at Clarett 2 and see the real conflict inherent in both of these. But what you're going to see is the triumph of the labor law, at least for now. And because the U.S. Supreme Court didn't grant certiorari to this case, the second decision in Clarett, is going to be the highest form of decision that we have on this issue of monopoly. So it's a very, very important decision. I need to make at least a comment and tell a brief story that I talked about today in a couple of different classes in a couple of different settings. Because labor unions are different in professional sports. They are symbiotic. They are not enemies. Almost no situation does an employer ever go to its employees and go, hey, have you thought about unionizing? And in almost no circumstance does an employer go, well, we really welcome a union because you're going to give us some other antitrust protection. No, in fact, they're usually mortal enemies. And what happens in pro sports is they hit this unique symbiosis. They need each other. They depend on each other. The league gets its antitrust protection from the union gives it and gets great benefit back in the form of free agency, in the form of new contract dollars, in the form of benefits. You name what it's going to be, it comes back from that antitrust dynamic. And in fact, ultimately antitrust law overlays and is interwoven with all sports decisions, if only because of the fact you get the necessary proper attorney's fees and the treble damages in the federal question jurisdiction, but also because it is a complex case and almost everything involves some form of antitrust violation. I want to tell the story of the two women's professional leagues that existed in women's basketball, because this story really does, I think, illustrate how important unions are in professional sports to give antitrust protection, and in turn, because most sports leagues are monopolies, or virtually every one is a monopoly, a natural monopoly or a planned monopoly, how important this antitrust protection is. Okay, if you remember about a decade ago, before the WNBA was founded, another women's professional league was founded in North America. It was called the ABL. The ABL included most of the top college players and players who did not go to Europe. It paid as much as $100,000 in some cases, which might have been a good argument for why it probably wasn't destined to succeed either, simply because it was paying almost too much money. On the other hand, I had about 4 or 5 clients in the ABL, and they were doing quite well. Of course, the NBA kind of tied up sponsors, acted a little bit predatorily, managed to survive an antitrust claim when the ABL ultimately failed after season 1, or in the middle of season 2, when the teams couldn't make payroll. But very interestingly enough, the WNBA, as long as there was a competitive league, as long as that competitive league was actually a little bit bigger than the WNBA, had virtually no interest in having a union. In fact, the WNBA had worked to keep a union out. However, the minute the ABL folded, and the WNBA was going to be a monopolistic player in women's basketball on the American continent, guess what? We need a union. And in fact, they held up a season to get a collective bargaining agreement in place and forced the men's basketball players union, or the NBA Players Association, to go ahead and organize the women players. They certified it quickly. Interestingly enough, the men's players union had no great interest in doing it, but they ultimately did. They got a favor back from David Stern. But it's interesting how that one came up and how important sports unions are to the idea of professional sports. They're symbiotic and there's no getting around it. The Clarett case really does show how joined these two are, how they can be peas in the pod, how they're agreeing in this circumstance. So we do have this new concept. We do have this new added antitrust concern, and we call that, as we said before, the non-statutory labor exemption. So if you were to be sued in antitrust, the first claim you would assert, I'm baseball. Obviously, in this case, we're not talking about a baseball scenario. We're talking about professional football. We look then at the idea that the labor market being burdened, and it clearly is. We look if there's a labor exemption that protects it. Oh, it is a labor market issue, but it's not in the collective bargaining agreement, so it's not subject to the statutory labor exemption. We next look is it subject to the non-statutory labor exemption? Could it, would it, might it be in the collective bargaining agreement? Have both sides agreed? In which case, we're going to immunize a lot of things that might not have been in collective bargaining agreements, that might not be protected by using the non-statutory labor exemption. It's certainly used to great power in the Clarett case, much to Clarett's detriment, much to Mike Williams' detriment. That year off for both players really ended their career, but we're always going to see that, and until we see some change in the current antitrust structure, Clarett is going to remain enormously important. I really want to thank you for listening in to me in this way. I don't know if this was a good format or a bad format, and certainly I didn't plan to come back in my gym clothes while doing laundry late at night to record the last session. I do want to thank you, and I want to make sure you go through the slide presentation that we've come to you in PowerPoint that's attached to this lesson. It is a cheat sheet for the entire antitrust field. But I really do mostly want to thank you for listening to me talk tonight, because you've done me a great favor by allowing me to get down and be with my father tomorrow in Virginia. I hope actually having this on YouTube to a degree might even help you if you need to go back and clarify the Clarett case, because again, the Clarett case is quite important. I should probably sing my way out by singing a little Video Killed the Radio Star. Oh, I like that song. Anyway, I'll see you next week. Have a great weekend, and thank you for listening.